I rise today to speak in opposition to the nomination of Caitlin Halligan to be a circuit judge on the U.S. Court of Appeals for the District of Columbia Circuit. The D.C. Circuit is arguably the most important federal appellate court in our country's judicial system, with primary responsibility to review administrative decisions made by many federal departments and executive branch agencies. It has also served in many instances as a stepping stone of sorts for judges later appointed to the United States Supreme Court. As a result, the Senate has a longstanding practice of carefully scrutinizing nominees to the D.C. Circuit. And when evaluating particular nominees, we've also carefully considered the need for additional judges on that very court. In July 2006, President Bush nominated an eminently qualified individual named Peter Keisler to fill a seat on the D.C. Circuit. Mr. Keisler, whom I know personally, is among the finest attorneys in the country and is also among the finest individuals that I know. Because of his non-ideological approach to the law, Mr. Keisler enjoys broad, bipartisan support throughout the legal profession. Despite these unassailable qualifications, Democratic senators blocked Mr. Keisler's nomination. He did not receive any floor consideration whatsoever, not even a cloture vote, and his nomination languished in the Judiciary Committee. At the time, a number of Democratic senators sent a letter to the Judiciary Committee chairman, arguing that a nominee to the D.C. Circuit, quote, should under no circumstances be considered, much less confirmed, before we first address the very need for that judgeship, close quote. These senators specifically argued that the D.C. Circuit's comparatively modest caseload in 2006 did not justify the confirmation of an additional judge to that court, even though this was a position that by law already existed. More than 6 years have passed, and Ms. Halligan has been nominated once again to that very same seat on the D.C. Circuit, the same seat for which Peter Keisler was nominated. But the court's caseload remains just as minimal as it was then. According to the Administrative Office of U.S. Courts, the D.C. Circuit's caseload is so light that the number of appeals pending per judicial panel is 54% less than the average for federal courts of appeals. With just 359 pending appeals per panel, the D.C. Circuit's average workload is less than half that of other similar appellate courts. The D.C. Circuit's caseload has actually decreased since the time Democrats blocked Mr. Keisler. Indeed, since 2005, the total number of appeals filed is down over 13%, and the total number of appeals pending is down over 10%. Some have sought to make much of the fact that since 2005, 2 of the court's judges have taken senior status, leaving only 7 active judges on the D.C. Circuit today. But the court's caseload has declined so much in recent years that even filings per active judge are only slightly higher than they were in 2005. Of course, that doesn't account for the 6 senior judges on the D.C. Circuit who continue to hear appeals and author opinions on a regular basis. Their contributions, the contributions of the senior judges on that court, are such that the actual work for each active judge has declined, and the caseload burden for D.C. Circuit judges is less than it was when Democrats blocked Mr. Keisler on the basis of a declining, insufficient caseload. Indeed, the average filings per panel, perhaps the truest measure of actual workload per judge in a U.S. Court of Appeals, is down almost 6% since that time. In each of the last several years, the D.C. Circuit has canceled regularly scheduled argument dates due to a lack of pending cases. And those who work at the court suggest that in reality, the workload isn't any different today than it has been in the past. According to the Democrats' own standards, and particularly when there are judicial emergencies in other courts across the country, now is not the time to confirm another judge to the D.C. Circuit. And it certainly is not the time for us to consider confirming a controversial nominee with a record of views that many view as extreme with regard to the law and the Constitution. And so make no mistake, Ms. Halligan is not what we would call a consensus nominee. The Senate has already considered and rejected her nomination. Nothing material has changed since that time. Many of my colleagues have discussed a wide range of Ms. Halligan's views, so I'll limit myself today to just one example. In 2003, while serving as Solicitor General for the state of New York, Ms. Halligan approved and signed a legal brief arguing that handgun manufacturers, wholesalers, and retailers should be held liable for criminal actions that individuals commit with those guns. 3 years later, in 2006, Ms. Halligan filed another brief arguing that handgun manufacturers were guilty of creating a public nuisance. Such arguments amount to an invitation to the courts, for the courts to engage in sweeping judicial activism. And the positions she took are both bewildering and flatly inconsistent with the original understanding of the Second Amendment rights that all Americans enjoy. In conclusion, as measured by the Democrats' own standards and their own prior actions, now is not the time to confirm another judge to the D.C. Circuit. And it is certainly not time to consider such a controversial nominee for that very important court. The Senate has already spoken and has rejected Ms. Halligan's nomination. I urge my colleagues once again to oppose her confirmation. Thank you, Madam President. I note the absence of a quorum.